Good morning, everyone. Thank you for tuning in to our High Notes webinar program this morning. My name is Erin Kopek, and I am the Director of Marketing with Higher Level, a human capital management company. And today you have joined our webinar program entitled What Employers Need to Know, Marijuana in and Out of the Workplace. So today, Ben Wessel-Smith with Sandberg, Phoenix, and Von Goddard will be presenting to us today and telling us all the great information, the new information that we're eager to learn. So just a few housekeeping things before we get started. The call will last close to an hour. Everyone on the webinar today, you are set up in listen only mode. If you do have questions, we will be answering those at the end of the presentation. So feel free to post your questions in the messaging function of the GoToWebinar toolbar. So let's get started. So Ben Wessel-Smith, he focuses his practice on complex and multi-party civil litigation, specializing in employment law, non-compete litigation, class action defense, and appellate litigation. Ben has experience representing employers in a broad scope of employment issues, including litigation and consent decree compliance with the Equal Employment Opportunity Commission, as well as high-stakes litigation world of post-employment restrictive covenant litigation. In his class action defense work, Ben focuses his practice on the defense of employers for wage and hour class allegations and on the defense of product manufacturers for product defects and alleged labeling defects. Ben also has extensive appellate knowledge, having formerly served as a judicial law clerk for the Honorable Robert M. Clayton III on the Missouri Court of Appeals, Eastern District. He handles a wide variety of appeals, but focuses primarily on interlocutory appeals to ensure the enforcement of arbitration agreements. Outside of the office, Ben is an avid amateur cyclist and vintage racing bike collector and spends most of his time with his wife and 2 sons. Ben, thank you for joining us today, and I turn it over to you.
Thank you. It's my pleasure. And thank you to everyone for being on the call today and taking the time out of your day to attend this webinar. Let's get started. So make sure the slides are clicking here. Might take a moment. Like you said, my name is Ben Wessel-Smith. I'm with Sandberg, Phoenix, and Von Goddard here. I'm based in the St. Louis office, but we also have offices throughout Illinois, including in O'Fallon, Illinois, Edwardsville, and Carbondale. Here we go. What employers need to know about marijuana in the workplace. And there's my contact information, which will also be at the end of the presentation. So I want to spend a little bit of time, not too much in the interest of time, on some of the basics that are going to inform the conversation today. Obviously, we're all familiar with the employment at will doctrine, that generally the employer can terminate an employee at any time as long as it's not an unlawful reason. And that unlawful reason is a big caveat that we're going to deal with, especially in the context of medically prescribed marijuana, but it's becoming a bigger and bigger question with regard to recreational use as well, especially in the states that have legalized it, including now Illinois. So we're all familiar with the American with Disability Act and other requirements under Illinois law that impose restrictions related to drug use, and significantly also with regard to addiction issues. A little bit of problem with the slide. Okay, great. So the ADA applies to qualified individuals who have a disability and are employed by employers with 15 or more employees. And like I said, I'm just going to spend a little bit of time on this. In order for the ADA to apply, you need to be a qualified individual because of a disability, and that applies to all aspects of the employment relationship. If an employee is a qualified individual, the employer has an obligation to provide reasonable accommodation. That's going to have some impact with regard to medically prescribed marijuana use. And the Illinois Human Rights Act provides for similar provisions. The ADA contains an anti-retaliation provision to anyone who opposes an act or practice which is unlawful. And that includes someone making a complaint with regard to their ability or inability to access their ADA rights. So generally, illegal drug use is not protected under the ADA. However, even if it's claimed that the drug use results from addiction. However, the important distinction is going to be that the ADA does protect an individual who has completed a drug rehabilitation program and who is no longer using illegal substance, or, and this is the big one, if the drug use is prescribed by a healthcare professional. The Illinois Human Rights Act provides for similar accommodations, and it prohibits discrimination based on a determinable physical or mental characteristic that is unrelated to their ability to perform the job duties. And that's going to be essential to all of the questions that we're talking about with respect to medical marijuana use specifically. Is this individual, your employee, capable of performing all of the job duties assigned to him or her? Again, having some problems with the slide.
Ben, can you try to use your arrow on your keyboard? Will that help?
I'm trying that as well. Well, I'll tell you what, why don't I, okay. I'll just go ahead and proceed with the presentation. Maybe we'll get the slides working. But I know that this is going to be available to everyone who's on the call after the fact as well. So we'll just go ahead and go through it.
Or I can click.
So the Illinois here we go. The Illinois Human Rights Act does not require the impairment to substantially limit a major life activity, and it also does not protect a person who engages in illegal drug use. Both provisions mandate that an employer has an ongoing obligation not to discriminate against its employees in the terms of their employment. That includes advancement opportunities, training, their evaluation, and any decisions related to terminating that employee. And those are some of the phases of the employment relationships that are going to be affected by those provisions, recruitment pay, everything throughout the entire course of employment, including unrelated other benefits that are not related directly to pay and advancement opportunities as well. Okay, so who is a disabled individual? This is a person who has a physical or mental impairment that substantially limits one or more of their major life activities, who has a record of that, or significantly an individual who is regarded as having a disability. And that applies under both the ADA and the Illinois Human Rights Act. So the real question then becomes, what do we mean by actual impairment? Employers are required to provide reasonable accommodation to an employee who is actually impaired. Both the ADA and the IHRA apply to prescription medication, and that includes opioids and significantly medical marijuana. So we're going to see later on that that has some conflict with other federal laws related to medical marijuana. So your obligation as an employer is to conduct an individualized assessment of that employee and to determine the impact of the accommodation for that employee that their disability and your accommodation would have on your organization. You need to conduct a sort of individualized study as to whether or not this accommodation that's being requested is feasible and possible under the circumstances of their employment. All right, what do we do about drug screening? Under the ADA, the employer's selection criteria in hiring or other employment actions cannot have a disparate impact on people who have disabilities. Medical examinations with regard to applicants for jobs are not allowed. However, job offers can be conditioned on the results of a pre-employment screening or medical evaluation if you provide the same examination to all individuals who are entering that job category, and they're subject to the same conditions. Now, the question is whether or not that applies to drug testing. A drug screening is not considered a medical examination within the meaning of the ADA. So the practical impact of that is that a pre-employment drug screen for an applicant for employment is not considered an improper medical examination, and it is permissible under the ADA for the employer to insist upon a drug screen for an applicant. So that also means that you can give an employee who has been off work with regard to a drug rehab program periodic drug testing if you have a reasonable belief that employee will pose a direct threat in the absence of periodic testing. So if you have an employee, for example, who's operating machinery or driving as a part of their job, it's reasonable if you have a reasonable belief that it's going to pose a threat by them performing those job duties. It's reasonable to insist upon that periodic drug testing, whether or not that employee is given the same test as other employees. So if you have specific concerns about a specific employee, that's not a violation of the ADA to provide that drug screening. Illinois law doesn't really tell us what we need to do. It's largely silent on whether or not you can or cannot drug test employees. An employer generally has discretion to formulate its own drug-free workplace policies and testing procedures, but the caveat is going to be as long as they comply with privacy and discrimination laws that we're going to talk a little bit more about later on. One exception to this is that the Illinois Public Works Project Act requires testing for all employers working on public works and receiving public works bids for jobs. Okay, we'll talk a little bit about some examples of how the ADA affects litigation with regard to drug testing and drug screening. This is a fairly recent EEOC case out of South Carolina. A preschool terminated an after-school teacher after he disclosed that he had a prior opioid addiction and was participating in a supervised medication-assisted treatment program. As part of that treatment, the teacher was prescribed basically an opioid substitute drug, and the court determined that the school failed to conduct an individualized assessment as to whether or not his use of that prescribed substitute opioid drug had an impact on his ability to actually perform his job duties, namely teaching, taking care of students at the preschool. And as a result, the school was forced to enter a settlement agreement and implement new policies and undergo ongoing EEOC supervision to ensure that they complied with all of their requirements under the ADA. This is another example recently out of South Dakota. In this case, the employer withdrew an applicant's job offer that had previously been offered based on a positive drug test, but the drug test returned results for prescription medication. The EEOC also alleged that the employer maintained an unlawful policy requiring all employees to report if they were taking prescription drugs as well as non-prescription medication. These actions, the inquiry into prescription drug use, violated the ADA according to the EEOC. And that resulted in a settlement as well for $45,000, as well as, again, implementation of new policies by the employer going forward that would involve EEOC monitoring over their compliance with the new procedures. A couple of takeaways. If you want to have adverse decisions related to drug use, you need to make sure that you're educated on the actual effects of that drug and whether or not it's going to have an impact on that employee's ability to safely perform their job duties. Because if it's a prescription drug and you haven't conducted that assessment, you're in violation of the ADA and similar Illinois provisions. And that also means that you should take precautions before implementing sort of company-wide blanket drug testing policies, unless you are prepared to articulate what our concerns about these drugs are and why we're testing our employees. I think we can probably go ahead and skip forward a couple and get to some different issues here. Okay, so what if we have a discrimination claim, and how do we prevent those with our existing employment policies and the use of last chance agreements? Generally, people who are addicted to drugs or alcohol can be qualified individuals. Now, that's an important distinction because the use of drugs or alcohol at work or as it impacts work is not protected under the ADA, but one's status as a person suffering of addiction, even especially if that person is a recovering addict, may be a disabled individual within the meaning of the ADA. So we can address those distinctions with our employment policies and with the use of last chance agreements. The important distinction is that we need to focus on the conduct. Clearly set forth the rules prohibiting drug use, or in this case, marijuana use, and intoxication from drugs, alcohol, or marijuana while at work, but do not implement a policy that discriminates against someone for being a user in the past or suffering from addiction. And then it's important that those policies be enforced consistently and discipline the actual misconduct, not that person's status as an addict or as a user. Okay, a little bit about last chance agreements. I don't want to spend a lot of time on this because not all employers use these, but generally a last chance agreement is an agreement with the employer and the employee to address an employee who has chronic underperformance or who repeatedly violates workplace rules with regard to illegal drugs or alcohol, or in this case, maybe marijuana that is in that employee's system at work improperly. So we're going to create an agreement to sort of deal with those chronic issues or repeated violations. It'll set forth that any future violations of workplace rules related to those issues will subject the employee to immediate discipline or termination. It's important always to make sure the last chance agreement is designed to prohibit employee conduct, so drug use, intoxication at work, without discriminating against that employee's disability status, if any. So typically your last chance agreement could address the type of penalties that would result from future violations. Typically you would want to set forth some specific types of employee discipline that would result from specific types of violations. So you could involve a suspension presently in order to address their addiction issues. You could implement certain successful completion of a treatment program as a precondition to coming back to work. You could get the employee to agree to submit to random or periodic substance testing, certain improvement in job performance metrics, set certain goals that they need to meet in order to improve their performance. And you always want to include an agreement to abstain from use of any illegal substances, alcohol, or marijuana in their system while at work as a precondition to continued employment. Always mean what you say if you use the last chance agreement. You need to set forth mandatory language. So if you want to set forth language that would suggest, like, if you fail a drug test in the future, termination will be immediate and there's no wiggle room on that, because the last chance agreement as a means to avoid a discrimination lawsuit and a way to win any potential discrimination lawsuit is only good if it's enforced across the board for all employees. So if you don't pull the trigger when that violation occurs, the message is sent that the employee behavior can continue, or that another employee, if they're involved in a last chance agreement in the future, will be able to point back and say, look, this previous person violated the last chance agreement and wasn't terminated. So my termination was a result of discrimination, not for my failure under my last chance agreement. This is a recent case out of the Eighth Circuit, well, recent-ish, this is back from 2003, but this is the Eighth Circuit held that last chance agreements are enforceable, and a good way to get out of a discrimination lawsuit. This case was for alcohol because this employee was arrested during non-working hours for a DUI while they had agreed in their last chance agreement to abstain from alcohol. And the Eighth Circuit held that that dismissal was proper because he was allowed under the ADA to place whatever voluntary restrictions on himself that he was willing to agree to, and he had made that agreement under the last chance agreement. Always make sure you include specific dates and prior communications within the last chance agreement to basically paper your file as far as what conversations you had with the employee so far. And there's some other elements set forth in this slide that you can include in your own last chance agreements if you choose to use them. Okay, let's spend a little time talking about the Illinois Right to Privacy in the Workplace Act. This is a really important statute with regard to marijuana use, and I think it's going to be the subject matter of some potential litigation in the future that we're going to see in Illinois, both in the context of medical marijuana use and in the context of recreational marijuana use. The statute was originally created basically to prevent employers from cracking down on employees for smoking cigarettes or tobacco use outside of work, and it's become a big source of potential litigation with regard to both medical and recreational marijuana use. Essentially, it prevents any adverse employment action based on the employee's use of a lawful product off the premises of the employer during non-working hours. So if an employee is a recreational or medical marijuana user, the Right to Privacy in the Workplace Act would prevent an adverse employment action based on that lawful use. So prohibited acts include the refusal to hire an employee, the discharge an employee, or any otherwise disadvantage with respect to that employee's job, compensation, terms, conditions, privileges of employment. This specifically excludes the ownership or use of a product that is otherwise specifically prohibited by law. So until very recently, this would have prohibited the ownership or use of recreational, non-medical marijuana, but now that that's been signed into law going into effect next year, that's not going to prohibit the adverse employment actions based on recreational marijuana possession and use. And we'll talk about that a little later on. So the most, like I said, the most important exclusion is that it does not apply to the use of lawful products which impairs an employee's ability to perform the assigned duties at work. So that's going to be a big carve out. And under this Right to Privacy in the Workplace Act, you can't discipline an employee for their conduct off the clock outside of the work area. However, if that person has used a product which impairs their ability to safely perform their work duties or effectively perform their work duties, such as marijuana still in their system while they're at work in a way that impairs them from doing their job, that's not going to prevent an employer from disciplining an employee or terminating an employee for that use. And we'll talk about that with regard to the recreational marijuana statute as well, because it contains a similar carve-out. Okay, it's also not a violation of this act to condition, for example, health insurance benefits with respect to the use of a lawful product. So, for example, if you have a group health plan that lowers a person's individual premium if they are not a smoker, or if they're not a marijuana smoker, or if they're not a drinker, those are allowable benefits under the Right to Privacy Act. Okay, let's talk about medical marijuana use under the current Illinois statutory scheme. So this is a big question nationwide, obviously a big question in Illinois as well. Generally, the employee positivity rates for marijuana are currently lower than they had been in the 80s, but have been steadily increasing ever since 2012 when medical marijuana became a nationwide movement, and recreational marijuana use has also increased the general positivity rate nationwide. There's a big problem, however, when you look at the current federal status. So under the current drug scheduling system in place under federal law, federal government classifies marijuana as Schedule I drug, and that means it's perceived to have no medical value. So, however, as we all know, despite this restriction, most states, 33 current states, allow usage for medical purposes, and 10 states allow for purely recreational usage, and Illinois is about to become the 11th state. This creates a problem with regard to the Federal Drug-Free Workplace Act, because under this act, an employer who has any federal contracts is required to implement a drug-free workplace policy if they have a federal contract of $100,000 or more, or receive any kind of federal grant. So if you have one of those federal contracts or federal grants, you need to prepare and distribute a formal drug-free workplace policy statement prohibiting the use or possession or distribution of controlled substances, and establish a drug-free awareness program to inform employees of the dangers of substance use, and ensure that all of your employees who are working on that federal contract or receiving funds under that federal grant understand that their personal reporting obligations. So the employer also must review the requirements of their drug-free workplace policy and offer information about counseling, rehabilitation, and other employee assistance programs that may be available. The big one, however, is you also need to notify your federal contracting agency or granting agency of any violation of those policies within 10 days, and then take direct action against that employee if they're convicted of a workplace drug violation. So this kind of puts employers in a difficult position, and employees as well, because they have to notify their employer of any drug violation, convictions for drug use, and then the employer must take appropriate actions up to and including termination, or require that person to participate in a drug abuse program. Illinois has a similar provision. It's the Illinois Drug-Free Workplace Act, which applies to state contracts and state grants. However, compliance with this act creates a rebuttal presumption that you're acting in good faith, and any actions you take under the Illinois Drug-Free Workplace Act are not going to be considered a violation of the Illinois Human Rights Act. So how does this comply and comport or conflict with medical marijuana use in Illinois? The Illinois Compassionate Use Act was enacted in 2014, and so far we haven't seen a lot of litigation in this arena in Illinois, but it legalizes medical marijuana use by individuals who have an approved debilitating condition. And as we know, that can take a wide variety of types of medical conditions that could qualify. Any individual also has to be registered with the state of Illinois as a registered user in order to medically use marijuana. All right, there we go. An employer may not discriminate against any individual solely on the basis of their status as a registered user. However, there's a carve-out under the law that this is the case unless failing to do so would cause you to violate a federal law or to lose a monetary benefit under federal law. So if you have a federal grant at issue or you're receiving money under a federal contract, there's a carve-out under the Illinois Compassionate Use Act that you can safely make your employment decisions based on that federal law. And employers are not permitted or required to permit or accommodate marijuana use or impairment at work under the Illinois statutory scheme. And you are allowed to enforce your written drug-free workplace policy. So if you want to rely on those provisions and those carve-outs under the Illinois Compassionate Use Act and the Illinois Drug-Free Workplace Act, it's very important to have a written drug-free workplace policy in place. So how does this clash, if at all, with the Compassionate Use and the Drug-Free Workplace Act? This is sort of an unstoppable force meets a movable object problem, because marijuana use and possession is illegal at the federal level, but medical use is permitted in Illinois and those other states. And in some cases, you're in danger of violating the ADA or the Illinois Human Rights Act if you prevent someone who's prescribed medical marijuana from using it. So like we said, the Illinois Compassionate Use Act prohibits discrimination based on the registered use of marijuana. So how do we think that Illinois courts will resolve this conflict? The ADA is a really big problem, I think, in this area, because it does not protect users of medical marijuana. It only protects legal drug use. However, now under the Illinois statutory scheme, that is marijuana use, if you're a registered user, does constitute legal drug use within the meaning of the ADA. And there's generally been a trend nationwide in favor of the employee and the registered user's discrimination status if the employer terminates or otherwise disciplines an employee for their registered use for a qualifying condition. We'll look at a couple of cases that have addressed this question nationwide. So far, like I said, there hasn't been any substantive Illinois litigation or appellate decisions on this issue, but the trend nationwide has been in favor of the employee and the registered user. This is a case out of Massachusetts. The registered user was terminated after a positive THC urine test. The employer argued it was following the federal law, so the Massachusetts law for medical use was not controlling. But the Massachusetts court found the employee was a qualified handicapped person under the Massachusetts state law. So providing an accommodation for that person and for their medically prescribed use was not unreasonable. The employer must show that the accommodation imposed on them created an undue hardship by impairing that person's job performance. So it was the employer's obligation and burden in that case to show that allowing this person to use their medically prescribed marijuana created a substantial and significant safety risk at work. The Connecticut case, actually a federal court addressing this question under Connecticut law, reached a similar conclusion recently. There, the employee rescinded a job after a Connecticut registered user tested positive for marijuana, and the court held that the Connecticut medical marijuana law contained an implied private cause of action, so they didn't even have to use the ADA or the Connecticut equivalent of the Human Rights Act. The Compassionate Use Act under Connecticut law was held to imply its own private cause of action. The employer was not allowed to rely on its zero tolerance policy because it exceeded what was required by the Federal Drug-Free Workplace Act, which does not require testing. So in that case, the employer required pre-employment drug screening, which is not required by the Drug-Free Workplace Act. So that additional requirement was held to violate that individual's right to use medical marijuana under the Connecticut law. We can look at how the Equal Opportunity Employment Commission has addressed this question. They have not been involved, to my knowledge, in any Illinois litigation on this issue, but generally the Illinois courts may look to see what the EEOC's enforcement actions provide for and adopt the EEOC's sort of way of thinking on this question. They've done that in many other areas of law involving the EEOC. So the EEOC's guidelines prohibit blanket disclosures of prescription drugs. So under that guideline, it's not permissible for an employer to require all of its employees to disclose whether or not they're using any prescription drugs, and that could include medical marijuana usage. So the EEOC enforcement shows that the employers are not permitted to inquire as to that employee's use of legal medical marijuana unless they have a reasonable basis to believe that it would cause a safety risk at work. And the EEOC also requires employers to implement procedures for participating in any substance rehabilitation programs as appropriate. So how do we think this is going to shake out in Illinois? I think it's an open question because the Illinois Compassionate Use Act specifically states that it's not going to be construed to create a private cause of action, which is different than what the Connecticut court reached. And this does not also apply to use outside of work. But to date, no Illinois decisions have directly addressed the question. I think the problem, like I said earlier, is going to be whether or not this Right to Privacy in the Workplace Act is going to prohibit employers from refusing to hire individuals for their legal use of products during non-working hours. And the courts could rely on that statute to create a private cause of action for legally prescribed medical marijuana use or recreational marijuana use. I think we can skip forward a couple here. Let's talk about a little bit more about medical or recreational use. Okay, great. I'll touch on this very briefly. The Opioid Act. There is a provision that encourages alternatives to opioid use for individuals who may be addicted to opioids, whether they're prescription opioids or other opioids. So there's generally a policy under Illinois law encouraging the use of those opioid replacement drugs, and an employee's use of any of those drugs is probably going to be treated as therapeutic under the terms of that act. So here's the big ticket, though, I think, that everyone's curious about, is the new recreational marijuana usage in Illinois. So the recreational marijuana statute was passed by both houses of the legislature and signed into law very recently on June 25th. It's anticipated that there's going to be a 6-month administrative rulemaking period, and the first sales for this will be allowed as of January 1st, 2020. Generally, there's going to be no consumption allowed until legal means to produce it are in place, but the fact that there have been so many medical marijuana production facilities already allowed, those places are ramped up and ready to produce domestic marijuana within the state of Illinois, and it should be available, I would assume, by those producers to be sold on January 1st of 2020. So it will allow adult recreational possession of marijuana and use for those individuals who are over the age of 21. You must have a commercial license in order to sell the flower, the edibles, and any other tested derivatives containing THC. The current cultivation centers and dispensaries are currently limited to existing facilities. So there have not been any licenses for any additional cultivation centers or dispensaries beyond those that are currently in existence for medical marijuana. But like I said, most of those are ramping up in anticipation of this January 1st, 2020 date, and they're only operating at as of maybe 10 to 33% of their capacity. So it's anticipated that these places that are cultivating marijuana for sale have the production capability to ramp up for recreational sale. New license categories will be in effect for processors, infusers, and transporters of recreational products. So in addition to those people who are already cultivating and dispensing, there's going to be new license categories for those who are sort of within the cottage industry of processing and infusing THC products. For home growth, people are going to be limited to 5 plants per household unless they have this commercial licensing in place. Public consumption will be prohibited, as well as open containers of the flower or the edibles. Any other products need to be in closed containers. Consumption on private property that's open to the public will be prohibited. There will also be a DUI provision, but it's not currently established what the minimal bloodstream concentration will be under Illinois law. That's still being considered under the administrative rulemaking provisions. And this varies state to state, so it's not clear what Illinois is going to do as far as what the concentration will be. Colorado has a much higher THC per millimeter requirement than Nevada, which is very low and would have a DUI for anything above 2 nanograms. So we'll see what Illinois law and the Highway Patrol come up with for that. So how does this affect employers? The employers still have the option to discipline or terminate an employee for off-the-clock cannabis use because it's still illegal under federal law. So the employers may be in a difficult position, however, if they're going to try to reconcile that Illinois law with federal law, and especially when you consider the Illinois Right to Privacy in the Workplace Act, which will allow for and prohibit penalizing an employee for off-the-clock usage. Again, we're going to have that unstoppable force immovable object problem, whereas it's illegal to discriminate against an employee for off-the-clock use of a legal product, but this is lawful to discipline an employee under federal law. So the statute as enacted contemplates this a little bit and gives employers a little bit of guidance as to how to address these issues, because the protections of the Illinois Right to Privacy in the Workplace Act do not apply to use while at work or impairment that is continued over to the employee at work. So under the Right to Privacy in the Workplace Act, the employer has the right to discipline the employee if there's something still in that employee's bloodstream that's impacting their ability to safely or effectively perform their work duties. And the Act has enacted a sort of broad procedure for how employers are supposed to deal with this. So if you detect that an employee is under the influence of cannabis while at work, you have some discretion to discipline that employee, and the Act gives some details on this. Generally, the employer needs to have a good faith belief that the employee is using marijuana or is under the influence of marijuana while at work by citing specific symptoms that are attributed to the effects of cannabis. It defines good faith belief as an employer may consider an employee to be impaired if the employee manifests specific articulable symptoms while working that decrease or lessen the employee's performance of his or her job duties or the tasks of that position. So it also defines what the symptoms you're allowed to look for and articulate are. That includes inhibited speech, physical dexterity problems, changes in the employee's agility and coordination, their general demeanor, acting irrational or exhibiting unusual behavior, negligence in their job duties, disregard for workplace safety rules, and any damage done to property or to another employee. Those are the sort of symptoms that an employer is allowed to look for, and that would provide a good faith belief, as is defined under the statute, as a reason to inquire as to whether or not they're under the effects of cannabis while at work. So the Act further requires that each employee must be given a reasonable opportunity to oppose the misconduct charge. So if you've articulated a symptom and a good faith belief, the employee has the opportunity to respond. It's a pretty broad procedure, which I think is problematic because this opens the door for possible opportunities for accusations of discrimination. So you need to be careful and aware that you're taking proper steps when identifying what you think is cannabis use in the workplace, and set forth particular steps for disciplining employees under those circumstances so that we're not in a position where one employee is treated one way and another employee asserts he's treated in a different way. There's also some zoning requirements and carve-outs under the Recreational Use Act. This statutory scheme leaves discretion to the local municipalities. Maine, Massachusetts, and Vermont have similar provisions. So if you're in a municipality which has created some zoning restrictions on the ownership, possession, or use of cannabis recreationally, then you can rely on those local ordinances to enforce your policies prohibiting any off-the-clock usage of cannabis. We still have this general big problem, though, which is the federal policy, which renders marijuana possession or ownership or use illegal. There have been some bills in Congress to reclassify it as a Schedule II drug, which would basically result in decriminalizing possession and sale. But those have really gotten nowhere at the federal level, and it still remains a federal offense to distribute marijuana, although that's typically not enforced against these sort of commercial facilities. We had a kind of broad policy against marijuana prosecutions under the Obama administration. That guidance de-emphasizing prosecutions was withdrawn by Attorney General Sessions, but we don't have any clear guidance on what the current DOJ is going to be doing under Bill Barr. The DOJ has some internal provisions related to this that emphasize continuous monitoring by state regulatory agencies. So that's basically a policy by the DOJ to kick out monitoring of marijuana distribution and sales to the state regulatory agencies. And that's going to be something that ramps up under the 6-month rulemaking provision here in Illinois. Okay, there's my contact information. And I know we went through a lot of different topics here, so we'll welcome any questions that people have had so far.
All right, thank you very much. So now's the time. If you have any questions, feel free to type those in the message box at the bottom of your GoToWebinar panel. All right, so Ben, we do have a question.
Great.
Let's see, how would this work if you are a federal contractor? If there were to be an accident at work, we are required to have the person drug tested for the potential workers' comp case. If marijuana is in their system, is it something they could risk losing their job for?
Well, the Drug-Free Workplace Act requires reporting. So I think that you're doing everything right by requiring a drug test post-accident, because if you have a reason to believe that that a person is going to be involved in an accident or is using something, you've done the right thing by testing them after the accident. If that shows a result, the Drug-Free Workplace Act requires certain steps to be taken afterwards in terms of reporting. It doesn't mandate immediate termination of that person. You know, that's up to your own Drug-Free Workplace Act policy. It does require certain steps to be taken as far as giving that person access to resources for drug treatment, requiring certain steps to be put in place to prevent that person using a drug in the future. But it doesn't mandate immediate termination. I think that you've done the right thing by doing that testing in order to fulfill your reporting requirements. You just need to take a look at what your drug-free workplace policy provides and make sure that you're complying with the sort of counseling and advising and reporting requirements of the Act.
Okay, great. We do have a couple people asking. The slides and the recording will be available after the presentation. We have a couple more questions. Can THC
Sure.
be included on a testing panel once recreational THC becomes legal in 2020?
Yeah, I mean, you can still require that this be tested or show up on a panel. The problem is going to be that person is permitted to use medical marijuana under the Right to Privacy in the Workplace Act outside of work. So if you're going to discipline that person for use or possession, it needs to be as a result of a good faith belief that they were under the effects while at work. And I think that the administrative rule making period is hopefully going to provide us with some guidance as to what sort of bloodstream level is going to be acceptable or permissible in terms of sort of a base level workplace amount in their bloodstream. But if they just show that they've used it outside or within the last however many days, or if you do a hair test, something to that effect, that's not going to be permissible to discipline that person under the Right to Privacy in the Workplace Act unless you have that good faith belief that it is impacting their job duties or causing a safety concern while they're in the office.
All right, we had another question come in from Rob. How can they still finalize the act for 6 months and begin selling on January 1st?
Well, it was signed into law on June 29th, so I guess it's not exactly 6 months. They're giving themselves whatever the time period was from finalizing it in June to January 1st. So I think it's a little less than 6 months, whatever that works out to. But it will be permissible for sale as of January 1st, 2020, assuming that the means for in-state production are in place, which I believe that they will be.
Does Missouri law or Illinois law take priority when an employee lives in Illinois but works in Missouri with regards to recreational use?
So there is no recreational provision under Missouri law. Missouri very recently allowed for medical marijuana usage, so it's behind Illinois in terms of the legalization scheme, and honestly I don't know that there's any real push for it or real likelihood that it's going to be passed under Missouri law anytime soon. If that employer is located in Missouri, Missouri law is going to apply to that employment relationship.
All right, we have another question here asking if this applies. Basically, they stated none of this applies to DOT, correct? We primarily employ workers who are DOT certified and need to be sure we are, need to be sure that be sure our options when they test positive for substances.
Yeah, and there's a slide that references that earlier that we kind of buzzed through, but the DOT has its own set of requirements, and basically all of these other statutory schemes have carve-outs for DOT-related issues. So if you have drivers who are subject to DOT requirements, those requirements are pretty much going to trump all these other concerns, and that's made explicitly clear under most of these statutory schemes.
All right, a couple more questions here. The ICUA, does this apply to all employers or just for the ones with 15 plus employees?
That requirement applies to employers with greater than 15 employees. That's pretty much all provisions of Illinois work use. But the concern is always going to be there are certain provisions under the Illinois Human Rights Act that apply to employers with only one employee. So it kind of depends what sort of discrimination claim is at issue. With regard to disability discrimination, the Illinois Human Rights Act applies to employers with as few as one employee under certain circumstances. So it really is going to be a question as to what type of discrimination case is being alleged and what the individual circumstances are. And I think you need to look very carefully at that if you have fewer than 15 employees. But that is generally correct that most Illinois discrimination law, as well as most federal law, is only applicable to employers with greater than 15 employees.
What about an employee coming back from their lunch break smelling strongly like marijuana? Would this be considered a behavior we could observe?
Well, you need to look carefully at the terms of the statute, because it does not apply to, a good faith belief does not apply to a smell or odor of marijuana. Now, if you can articulate that person has some sort of behavioral issues or is exhibiting some sort of unusual inhibitions at work, then that's the sort of thing you need to look for. But odor is not set forth under the statute.
All right, Ben. Well, that wraps up our questions. I appreciate everyone spending their morning with us and keeping the conversation going. We look forward to kind of navigating this with you. If you want to sign up for our webinar programs in the future, we do this on a monthly basis. Feel free to email hello@higherlevel.com, and we will add you to our list just for future communications. And we will also make sure that we send out the slides and the link to the recording after we wrap up this morning. So thank you again a bit, Ben, and everybody have a great day.
Thank you, everyone, for your time.